Hello, everyone, and welcome to a live edition of Everything Compliance. We've got the gang with us today, and we're going to take up a variety of topics. As usual, we're going to go east to west. So, Matt Kelly, then Jonathan, then Karen, Jay. So, Matt Kelly, what has been on your mind?
Well, Tom, I have been thinking about cybersecurity and most specifically the SEC's new proposals, cybersecurity disclosure. For those of you who have not yet seen this, the proposal was put out in about March. It is out for comment for 60 days. I think we're already halfway through that comment. Number two, what did the SEC actually propose? So in a nutshell, those two different types of things. They proposed enhanced Excel disclosure within 4 days of material cybersecurity events. You would need to file a Form 8K from 4 days from when you decide the event is material, not when the event actually happened. So if you are not sure if it's, you want to take some you're doing, then you decide, okay, it's material. Now you have to file an 8K within 4 days. So that's one big bucket of disclosures that the SEC has floated. I wanted to talk more about the others, which were annual disclosures in the 10K of how the board and management approach cybersecurity. Because I think that's on how any organization about cyber governance, even if you're not a publicly traded company, even if the SEC decides we're not going to move forward, which they're going to move forward with it. That I'm sure of. What will the final form be? No, but they are going to push something. But even if they did, I liked this issue because it really raises some good that any compliance and risk management teams and senior executives and boards should be thinking about. So I wanted to kind of touch a bit on what governance disclosures that a company might hear, and what would a compliancer and a CISO then be thinking about on the in-house side? If this is what the board is saying, what are we giving to the board for reports? That kind of. So specifically, the board would have to be disclosing in the 10K whether the whole board thinks about cyber. Is it specific board members? Is there a board committee responsible for oversight of cyber? You'd have to talk about that. You'd have to talk about the processes by which is informed about cybersecurity risks, who is reporting to the board, how often, is it every board meeting, is it only when there's an incident, is it just some sort of casual, informal presentation from time to time, whether and how the board or its committee, how you consider cyber risk as part of business strategy and risk management and oversight. Then you would also need to think about management role in cyber. So certain management positions or in-house committees that are responsible for measuring cyber risk and monitoring it. Do you have a designated CISO? Who does that CISO do on the org chart? Do they report to maybe, presumably the CEO, but maybe to a chief technology officer, maybe to a general counsel, people who might CISOs reporting to a GC, totally nuts. No, it's not. That's actually what Facebook used to do right up until it had its massive breach that blew up in its face in 2017 or Cambridge Analytica and Russia and Trump scandals. But before all of that, CISO reported in general counsel at Facebook. How often does management report on cyber issues to the board? Things like that. So there's a lot there. I think first I wanted to say, what is the SEC really trying to here? I think they're trying to get the board to think about cyber fundamental to good operations. If you do not have cyber governance going well under you're well in hand, you don't have good operational risk management. So that's a big point of mine. And some people say I'm wrong, but I would say effective cybersecurity and operational risk are one and the same. Because show me what part of the modern enterprise works well without IT. Because I can't find it. Finance won't work well. Sales won't work well. Legal won't work well. HR, everybody else. Compliance, that won't work well. If you don't have your risks well under control, Your company is not good with its operational risk. Could blow up at your face at any time. And I think the boards are going to have to really come to terms with what does that actually mean. So any company where you're going to present cybersecurity as a technical thing, we are in full compliance with these privacy regulations. We had these many intrusion attempts and we blocked this many of them. And we had this result from our penetration. All that technical stuff, I don't think that's going to cut it with the board. First off, it'll make a lot of board members, your eyes are going to glaze over. And I don't think that would be unwarranted because they're not technical people. They are business strategy people. So this conversation about cyber is really going to have to shift to, here's how much we rely on cloud-based providers for all of our critical infrastructure. And we don't spend this much, and we don't approach governing those service providers in this way. If we don't do that, we can't necessarily maintain business continuity in the event of a disruption. That's the sort of business frame discussion of cyber risks that I think the SEC wants. And like I said, even if the SEC went poof with this rule tomorrow, that's what every board should need to think about for cyber. Public, private, I don't care, US-based, Europe, anywhere in the world. You need to be thinking about how is cyber driving our strategic risks? Is it going to box us into a strategic corner? Are we investing enough in business continuity? All sorts of other things, all of it based on what are our risks that arise from how we use IT. And then I did want to talk a bit more just about on the in-house side for any compliance officers who maybe do not talk to the board as often as you'd like, and as often as you should, but you're like, what does this mean for me? Well, I would say, and I've been talking with a lot of IT thinkers, cybersecurity thinkers, board directors, what does this really need for management on the in-house side? Like a cyber risk committee, in-house, enterprise-wide, with senior executives. Who's going to be on that? Probably the CISO would be the chair of it, legal team, compliance team if it's separate, maybe the IT team if it is separate from the IT security team, sales team if they're working with a lot of cloud-based providers like Salesforce, business units, other operating units. We're going to be thinking about what are the technical controls we should have in place to assure good security? What are the policies and training we should have for employees? Even if the technical controls are great, if our employees don't know what they're doing or why, they could still subvert those controls. You're going to be needing the operational risks we should plan for. What does that actually mean for capabilities we need to have? Scenario planning. How would you actually go through a tabletop exercise of this provider went down, this provider got hit by a ransomware attack, this operation unit over here is non-functional for 3 days. What is the business continuity issues you have to think through? Who are those third-party providers that we have? How did we find them? What is the onboarding for them? Have we documented that they have strong cybersecurity? Have we collected that all so we can analyze it or present it to others? That's the sort of stuff that we need to be thinking about for cyber. So it's intriguing to me, and I'm almost done, because I think that compliance is not going to run a lot of this, but this will not be able to run well without compliance being buddy-buddy with the CISO, because they're going to be thinking about operational risks, and you have to be whispering in their ear about, well, here's the other regulatory compliance risks we have, GDPR, for HIPAA, for the Gramm-Leach-Bliley Act. And this is my concerns are going to have to manifest as policies and procedures and internal controls we have to put in place, business continuity or not. And then the two of you and others have to get together with a game plan of what are we going to present to the board this quarter to talk about our ITs and how they're shaping our business strategy and the options we have. So there's a lot there, and I'm actually very glad that SEC has put that out there. I look forward to whatever kind of final rule they're going to put forward. But like I said, even if there were no final rule, this is stuff everybody needs to be thinking about. So they kicked the football onto the field, and it's an important thing to look at. And that's what I had this week, or this month.
Jonathan Marks, do you have a question or comment for Matt?
No, I think if you're a listener out there, everything that Matt said, I hope you were quick enough to write it all down because it all makes sense. But more importantly, the one thing that Matt talked about were these tabletop exercises. But I would take it a step further and say if you don't have a crisis management plan that is absolutely ready to go, and I mean absolutely ready to go, you're going to be in deep trouble because we're in an environment right now where everybody wants to know about everything yesterday. And that doesn't mean that when you have a data breach and you realize that you're in hot water, that you go start hiring professionals to try to get them on board. It means that if this happens and the bell rings, you have people ready to go to slide down the pole, put on their outfits, hop in the truck, and put out these fires right away. Because otherwise, you're going to get burned. And I can't think of a better analogy than that. So, Matt, I totally agree with you. And then the other thing that I wanted to say was, thank you so much, SEC, for agreeing that we should notify the public if, in fact, there is a cyber breach. But if the chief audit executive or the chief compliance officer resigns, we're not going to say anything about that.
Excellent point.
So I have a question for you, Matt, but I want to loop Karen in, perhaps from the legal angle on this. With this SEC proposal, if some or all of it becomes SEC regulations, you think this is going to up the stakes in terms of the Delaware Supreme Court and their Caremark standard about what companies must do with serious operational risk, whether that be in compliance, whether that be in safety or health, that we've seen in some other cases? But is that now going to rise to a potential Caremark standard?
Well, I certainly think that it could. And in fact, you're mentioning Caremark, but the case that comes to my mind a lot, it was the Bluebell Ice Creams case, where it was a food business and the board was just kind of mailing it in on food risk, where the Delaware court basically said, no, you need to roll up sleeves and get your hands dirty here. Food business, you have to really take action on food risk. And by the same token, I think that, you have the Sarbanes-Oxley Act and financial reporting risks, where every single company, you can't just sit around and wait for the CFO to tell you financial reporting risks are in hand. That's not feasible. Financial reporting is one of the core duties of what the org does. Now, if you look at the COSO framework, what are the other two? One is compliance and one is operations. And like I said, I think cybersecurity operations risk are fusing into the same thing. And maybe we're going to be at a standard where courts are going to say to every board, you can't just sit around and wait for the CISO to say IT security risk and operational risk are fine. And then you think, oh, yeah, well, it's good. No, I don't think that's going to happen. I think that eventually when some company screws this up, which they will, and somebody sues, then they're going to start ruling that, no, you need to get your hands dirty and roll up and really get into how cyber is or isn't threatening operational risk.
Aaron, do you see potentially Delaware Supreme Court expanding Caremark into this area?
Well, I don't know if I want to necessarily go on record to say that the Delaware Supreme Court will expand Caremark, but I think there's some, I guess in effect they will, in the sense that the needle is moving toward Caremark meaning a little more than maybe we have seen it meaning. So if that's an actual expansion of the standard, maybe by inches, and I think that actually will matter. And even the case that Matt referenced, the Bluebell case, was the first sort of movement we've seen toward this idea that the board might not be completely insulated by some of the protections we're used to in the business judgment rule. And I think situations like this, particularly when the SEC requires companies to know this, to be aware of this, then there is definitely this idea that you should be on notice if there are any red flags in your company. And red flags even can be the absence maybe of something, the absence of adequate policies and procedures in case this happens. There's not going to be much grace given, I think, by either the SEC or the Delaware courts to suggest that the board is doing at least even the bare minimum or meeting the Caremark standard, which is doing more than nothing and being aware of red flags and taking steps to ensure that they are living up to their fiduciary duties of protecting the company. And we now have enough information about cyber risks and what is maybe a standard, for lack of a better word, of what should be in a cybersecurity type protocol, that the board can't ignore that. And so not doing those things certainly would raise a Caremark problem.
Jonathan Marks, another comment or question?
Yeah, just one more follow-up thing. Matt, you mentioned the Bluebell ice cream case and the board actually having to really get their hands dirty and dig in. I agree. I also think that if you're a board member right now, you're probably a little bit apoplectic because everybody that does ERM, God bless, everybody that does enterprise risk management probably has cyber risk as one of their key risks, and it just can't be written on paper. Tom, I remember 14, 15 years ago, Tom and I, and maybe even Matt, were talking about things that are just written on paper, sort of these paper tigers. Some of these ERM programs are really going to be put to the test because it's just not about putting a risk on a piece of paper and saying, "Oh, we've identified cyber risk as one of our key risks." You're really going to have to get your hands dirty and really understand operationally how it's going to affect your organization. And like I said, as part of that, if you don't have a crisis management plan ready to go, you're going to be in big trouble.
Matt, I have one last question for you. Do you see some of the your comments around the structural forms of corporate governance that may need to be implemented? Should that be reported in a 10-K as well?
I would think so. I mean, first off, this proposal raises the question that's been around for years now. Should the audit committee oversee cyber? And I don't know why that question has been around for years, because the answer, I think, is just clearly no, they shouldn't. I know a lot of them do, but that doesn't mean that it's the right thing. But especially for larger businesses, I do think that the board might want to consider constituting a risk and technology committee, or just a risk committee. Some other day we can talk about ESG risks and whatnot and shoehorn them in there too. But the audit committee has a day job overseeing the audit, and that is not easy. So I think that, you would not, the proposal does not say you must do that. It says, what are you doing? So I think a public company that comes out and says, well, we are still just leaving it with the audit committee, and no, we don't have, say, a CISO on our board, that's not going to look good. That is not a flattering appearance to the investors. So I do think eventually this is going to jar large company boards to kind of revisit the wisdom of their board structure if they have not already done so.
Jonathan Marks, what is on your mind?
I'm going to talk about what we were talking about before the show today, and just because there's been a lot of conversation about it this week, and that is tone at the top and conduct from the top. I mean, if you look at the enforcement actions and even the things that we're talking about now, the focus on individual liability suggests that there is an emphasis on the conduct from the top, as opposed to the more, I guess, widely used term tone at or tone from the top. To me, tone from the top, it's really passive in nature, whereas conduct from the top is really more active. It's really emblematic of the need to ensure that ethical and cultural identity of an organization really does flow from the very top, with the board, senior executives, and middle management playing an active part in influencing, embodying, and demonstrating an organization's culture. And so I know if you read the evolution of compliance program, the guidance that came out from the DOJ, it does talk about misconduct, and it does really say this. But I wonder whether we're really taking this seriously, in practice today, and really have we really focused on what that really means, conduct from the top. So I'm interested to hear what everybody has to say. I think it's something that probably needs to be further developed, but the more, Matt mentioned this before, the more you look at enforcement actions and the more you see what's going on from an overall, from what I see in practice, the tone is, yeah, that's great, but is it really more the conduct from the top? And then how do we deal with it?
Matt, do you have a comment or question for Jonathan?
I think that Jonathan is onto something here, because what sticks in my mind are two recent enforcement actions we've seen lately where conduct at the top seems to be part of what's going on with the regulator. So number one was the Public Company Accounting Oversight Board just recently put a sanction against former vice chair of the audit practice at KPMG for failing to supervise his minions at KPMG in the mid 2010s when they engaged in that wacko scandal of offering jobs to PCAOB staffers in exchange for them leaking intel about upcoming audit inspections, where people were indicted, people went to prison, all sorts of stuff. And now, finally, we have seen that the PCAOB is trying to hold a senior audit firm official there responsible for poor oversight. He wasn't taking action to quell this sort of behavior. So that's example one. And then just the other week, we saw the Consumer Financial Protection Bureau. They filed a lawsuit TransUnion for failure to improved compliance procedures to restrict deceptive advertising practices that have been going on TransUnion for a while. But they also brought an action against the former president of one of TransUnion's subsidiaries, who basically was kind of slow walking all these reforms that the CFPB had already said, and TransUnion had agreed that it would implement. We're going to do a couple of these things here, and then they never did it. So now the CFPB is filing a lawsuit to get some action done here, but they have brought a complementary action against a former senior executive of TransUnion as well. Kind of like, again, because there was not enough good conduct at the top, not just tone, actual conduct. So I think Jonathan's onto something.
Jonathan, I was struck by your remarks about the evolution of compliance. And certainly 15 years ago, you and I were talking about putting things on paper and what needed to be on paper. The Department of Justice has evolved beyond that. And we as a compliance profession have evolved beyond that. In 2012, we had the formulation of the 10 hallmarks of an effective compliance program, where it was tone at the top. And then we had in 2019 and 2020, in 2019, the evaluation of corporate compliance programs, 2020, the update to the evaluation of corporate compliance programs, and then a second edition of the FCPA resource guide, which gave us the additional formulation of the 10 hallmarks of an effective compliance program, now just hallmarks because there's 11. But the DOJ has clearly evolved in its thinking, specifically in the 2020 update to the evaluation of corporate compliance programs, where they did say that. They did say it's more than tone, it is the conduct of senior management. And when you tie it into the enforcement actions you and Matt both discussed, I think you see clearly this evolution. Compliance is not a static program, it's a dynamic program, and it's dynamic because as we build and grow and learn, we see new strategies and new tactics. And when you wed that with enforcement actions, you clearly see the DOJ moving forward. And if we could even perhaps tie that into the Lisa Monaco speech from last October, where she talked about culture and how that will be evaluated, it's all tied into not just what the tone is from the top, but does senior management actually walk the walk while talking the talk? So I think you're absolutely onto something. But for me, the bigger, or at least one lesson is we do evolve, and compliance programs do evolve. And simply because you have met the paper requirements of the hallmarks of an effective compliance program, that may not protect you from an enforcement action. And I guess the long-winded question I want to ask you is, were you actually, in the discussions you've had with clients and colleagues, were you getting pushback that people said, no, all we do have to have is tone. We don't have to act out on this tone? Or what was the kind of general tenor, if you can, about the conversation?
Yeah, it goes back to this sort of set it and forget it. Yes, we built our compliance program. Yes, we have messaging from our CEO that talks about we have a whistleblower hotline and we have a code of conduct. And I'm like, that may have been good 6 years ago, but it's certainly not good today. To your point, this evolution part, there's no thought about evolving the program, which is really sad. There's no thought about using the feedback that you get in order to make your, managing risk in the compliance program better. And so, that's what sort of led me to this whole thing. I'm like, it's way more than just saying words. It's way more than just putting things on paper. It's the actions of senior leadership that are really going to push this all the way forward. And I got news for you. I said, I went out on a limb and said, if I were a regulator and I was looking at a company, and Matt brought up some really great examples, it's just a lot more than just saying that you've done it. It has to be the conduct, which I think is a more active type of an activity. And you have to be able to influence others within the organization, not only by the tone, which I think is important, but the conduct I think is equally, if not more important these days. So, it was an interesting conversation. It went on for about 2 hours, but I was more awestruck by the fact that they just, it was sort of this set it and forget it attitude. Okay, we did it. Here it is. We're happy. We don't, we built a Chevy. We don't need a Cadillac. And it's never going to be more than that, but we're not going to do anything else with it. We're going to leave it alone.
Karen Woody, you have been a securities law practitioner and now you're a securities law professor. Can you tell us about the gift that keeps on giving?
I was going to say, I wonder if there's such a thing as podcast malpractice for not talking about Elon today. Or just honestly, just being a citizen of the world. The whole world is talking about this guy, and maybe for good reason, but who knows? He is the gift that keeps on giving. I call him a walking law school exam because every single day there's a new headline. I think, oh, that's a great exam prompt because it's another, can of worms we're opening. This last week, I gave a lecture about everything he had done up until last week. And now we have a whole new week, a whole new set of facts, whole new set of circumstances that force us to take a look at what Elon is up to. So I don't really even know how to get my arms around where to start or what aspect of this to talk about. Maybe in addition to the gift that keeps on giving, should be also deemed the man who's launched 1,000 lawsuits, because that's what we're after here. So which lawsuit should we talk about today? Today, I kind of want to think about the one that actually does go to his activity last week about his filings with the SEC, about saying he was, had more than 5% stake. We now see people have filed a lawsuit about the potential insider trading really that's happening there. So for anyone who has been on vacation for a week or under a rock, last week, Elon Musk announced that he had a 9.1% stake in Twitter. And there was a whole lot of problems around that announcement. The first was which he initially filed it on a 13G disclosure, which said that he was going to be a passive investor, which that was one problem because he's not a passive investor. The other problem about that filing is that he missed the deadline of filing that. So again, if anyone has been kind of under a rock here, the minute you have a 5% stake in a company, you need to disclose that to the SEC. It's why most people are sort of lurking in the waters at 4.9%. And when you hit 5, the clock starts ticking and you have a 10-day disclosure window. Ironically or not ironically, the SEC just in February passed a proposal trying to shorten that window because it's an obscene amount of time before you actually have to disclose. That 10-day window is when typically activist investors make sure when they disclose 10 days after crossing the 5% threshold, that disclosure looks way north of 5%. That's sort of the game there. You hit 5, you hit go, and you get everyone, rallied to make sure that when your disclosure comes out, it is, as Elon's was, I actually have 9.2%. That's sort of the gamer. So the fact that everyone acknowledges that already is a bit of a lopsided amount of time, that's been, again, bandied around the SEC. And they finally made a proposal just a few months ago saying we want to close that window or at least shorten it to 5 days. I posit that that's still too long. We're in an instantaneous trading area here. We don't need to make sure that people, count all the, chips from the floor of the trading floor, any of that. Anyway. Point is, Elon misses the deadline by a wild 11 days, despite being a very lawyered up individual. So that's the first problem. And then again, he amends the filing to say, I actually am not going to be a passive investor. I'm going to have a more of an activist role. So he fixes that. But the question I think that is an interesting one, again, of the many issues we can discuss, I'm not even getting to even the takeover bid necessarily at this point, although of course this gets up to that line. But the interesting thing is that in that time period in which he has sat on the fact that he's over the 5% threshold and has the 10 days have lapsed, the lawsuit now that's being filed is saying, well, like, think about how much money it is you are able to trade on and essentially in an inside fashion, meaning once the disclosure comes up, I think shares in Twitter jump $10. I think they're around $39 before he discloses, and then they jump to $49 because of that announcement. So when you think about the fact that he is trading and buying a lot of Twitter after his 10-day deadline, he's buying it at that lower price because, however it is that he's able to trade in this, the market doesn't yet know what he's up to. So I think that in itself is a fascinating angle to this. The reason it's fascinating is because typically the SEC might not really take you to task. They have a few times in certain situations. They're not really going to take you to task all the time on sort of the potential foot fault of being late on your Section 13 filing. But here they are, for two reasons. One, it's Elon. There's going to be a day when the SEC is not looking to maybe get Elon, in front of them to really talk to him. They're not necessarily the best of friends these days. So that's one. The SEC is not going to let that one slide because it's Elon. I think that's one major reason. And then the other major reason is exactly what ends up happening here, which is he's late on the filing. So he comes in at 9.2%. And now we are in today's world, which he's now made a takeover bid. He's turned hostile about it after, again, this dance with trying to do a seat on the board and, stopping any additional aggregation of shares. That obviously didn't work. So we're in the situation we are in today. And query how much of the fact that he had that extra 11 days, which maybe, like I say, is just a bit of a filing foot fault, hard to imagine. But that actually does, I think, become a very problematic issue for anything that happens going forward. I know everyone in the world now is an expert on Elon Musk and on hostile takeovers as of today. So I welcome the actual expertise of this panel and others to tell me your thoughts about that.
Matt, do you have a question or comment for Karen?
I guess I have a question that I was intrigued that Elon's announced his takeover bid the day after Charlie Gasparino on CNN, who is the other overrated blowhard in this world, in my opinion. But nonetheless, he announced that Elon is under investigation by the SEC and the Justice Department. That was interesting for me because now it's real. But I was wondering about, I do think the SEC could certainly make some insider trading, market manipulation cases. Elon clearly goes around the world poking fun at the SEC at every opportunity. He gave a TED Talk in Vancouver just the other day where he was basically dumping all over the SEC. And I kind of wonder, much is his clearly stated attempt to antagonize the SEC. Does that introduce any sort of criminal liability that the Justice Department is going to get up in his face for any number of reasons for what he's doing? But I mean, he's almost like saying, here I am, world, come at me. I don't think that's really the wisest thing to do with the Justice Department ever. But what's your read on his criminal exposure here, if any?
I mean, I absolutely think he has some. I mean, well, 10b-5 already has concurrent, jurisdiction there, and you have to show scienter. So you already are dancing along the, knife edge of criminal civil liability right there. And I do think this is one that, like you say, he's just sort of thumbing his nose at these regulators, and no one's going to take kindly to that. I think that this would be one that could easily be referred to the Justice Department. Also, in terms of the magnitude of this isn't sort of small pennies in terms of the dollar amounts, the actual market manipulation that's occurring here. I think this is easily one that the Justice Department is very much taking a hard look at.
Jonathan Marks, do you have a question or comment for Karen?
Yeah, I'm just wondering how long this has been brewing, and all the articles that I've been reading, talking about Twitter going on the defense with their poison pill and the like. I wonder how effective that's really going to be. And so I'm just curious as your comments on all of that, because I mean, it seems like we're ready for a good down and dirty New York fight.
That I think is true. So obviously the board has the Revlon duties to take the best offer when there's a hostile offer thrown out. I think there is a decent defense for the board in the sense that Elon himself is such a character and has already threatened to tank the stock. They don't take the offer. And so if the board's defense is like, this was not the corporate policy or, where we wanted to take this company, this is a completely different direction. This is getting sort of into the weeds, but there's a famous case about the Time Warner merger and Paramount trying to sort of lob an offer in and shake that up. And so the defense that the company ended up winning on, which is Time, was saying, well, no, this was always our plan. We're always heading in this direction, and this is going to be too big of a pivot. So that's why, sure, Paramount came in at a higher number, but for various reasons, we're not going to go that direction. A little bit of a stretch here, especially when Elon's coming in at a high number. Like, how does the board legitimately keep their fiduciary duties and reject that offer? I think there's somebody who said that there might be a reason you are protecting the company by not letting that guy take over. I don't know how much that's going to win, but and I think they're also running down other options. They've talked about the poison pill. I know Vanguard is in the wings, maybe of having a big. There might be a white knight type other situation. Someone else will sweep in. Elon maybe has some funding issues here. Well, I mean, that's its own. Like I said, which side of the elephant do we try to even attack in terms of talking about Elon? That's another one. How is he getting this funding? I did have someone suggest that I bet what he'll try to do is make sure this all happens on 420, just to keep everything, just really circle that square or whatever. So, I mean, we'll see. It's the great thing. It's the great, corporate securities law telenovela of Elon Musk.
Karen, let me pick up on one of your last points, because can a board consider what a sale might do to the company? So if the board considers that he would either destroy the company, he would open it up, which allow comments from people as diverse as Donald Trump or other right-wing groups that could damage the company after the acquisition or the transaction. Is that something that the board can consider as well?
Yeah, I mean, and when you think about really at base what a fiduciary duty is, it is putting, the best interest of the company first, certainly before their own, things like that. And so if you think there are factors other than price that suggest at least that this is not in the best interest of the company, that's kind of where I was going with this idea of this is not the direction the company's going. We don't think this is one that is in the best interest here. That I think is a decent, solid argument that I would think even the Delaware courts would entertain. So I think that is one. And like I said, and Elon, he has a lot of money, but there are a lot of exhibits in that transcript of why he might not be great for also running Twitter. So we'll see.
Jay Rosen, do you have a question or comment?
Yeah, Karen, I don't know how this would actually work, but is there some way for the government to step in for the greater good in saying that Twitter is almost like the phone company, or it's almost like a utility that we can't allow somebody to monopolize, even if they would do it on April 20th?
That is an amazing question. Can we nationalize Twitter? Wow, I hadn't thought about that angle. I'm trying to think even through how we eminent domain Twitter or something for a general best interest of national security, or whatever the word. It's a good argument. I can't imagine that sort of the other side of the aisle would be okay with taking a private company and having the government take over it. But sure, I mean, I can't imagine it's going to happen, but that's a fascinating angle. I mean, maybe you could try to say there's some constitutional protection but no. At the end of the day, it's a private company. I don't see that being a winning argument.
Matt?
Yeah, well, I just wanted to chime in there because that's actually something that Elon has talked about with his pseudo claims, the defender of free speech. I do not believe that is true, and I don't believe that he is. But he has said that Twitter is like a public square, and so therefore they should be allowed to say what they want on it, including the likes of Donald Trump and January 6th insurrection extremists and who knows what else. I fundamentally disagree with that whole premise because Twitter is not like the public square. Twitter is like your local community newspaper where people can write in articles and it is privately owned and the private owner publishes it. And the private owner is responsible for whatever somebody is whatever under their newspaper. Now, I've been in the newspaper business pretty much my whole life, and I'm very kind of stuff. But it is baloney that Twitter censors or anything like this. I've said it before. Companies do not censor. Governments censor. So Twitter is like a giant community newspaper with 300 million subscribers who can all automatically write in and publish their own little take about what's going on in their neighborhood. And, really, if you wanted good governance of Twitter, I would be wholeheartedly in favor of repealing that Section 230 of the Communications Act, where legal liability would attach for what Twitter and Facebook and others are saying on social media. And you could be sued for allowing people to make impolitic or incorrect or inflammatory or insurrectionist statements. Yeah, all for it, because that's the same thing that newspapers think about every single day, and they have 100 years. I'm getting ahead of myself. I'm getting into the rants and shout outs early, so I'll stop. But Jay, to your point, I agree. And no, that's never going to happen. But I also do not think that.
Well, I want to take that point, perhaps not as far as eminent domain, but maybe pose in a little bit different way, Karen, because I've been thinking about the Business Roundtable's statement on the purpose of a corporation. And in that statement, they expanded the duties of a corporation from beyond simply the shareholders, or as you've articulated, the law, which is the fiduciary duty to represent the best interests of the shareholders. There were other stakeholders listed. That included customers, that included employees, that included localities where a business might operate. It included shareholders. It also included third parties who may do business with an entity. And could this be a vehicle or mechanism for us to have that broader debate about what is the purpose of a corporation, at least perhaps even in the public domain, recognizing that the fight would be in the courts of law, but could this be a way for us to have that broader discussion?
Absolutely. And Twitter, as Matt pointed out, is unique in its purpose and function. And so maybe no better example to run with that idea of, and I think, as you said, even Elon himself is sort of trying to tease that out. But it is an interesting, and even to Jay's point, nearly utility to some people. And so maybe that is something that, of course, just by nature of what Twitter is, it inherently demands that we consider stakeholders' consequences, people certainly that are go much broader than the shareholders here.
And so, Karen, I want to end with a completely different direction. Has this events over the past couple of weeks made securities law professors and learning about securities law incredibly sexy now? And your profession
wasn't it sexy, Tom?
jump to the top of the law school curriculum, because how can you have more fun?
Exactly. I hope to see a big uptick in enrollment in my classes now.
Jay Rosen, you have an incredibly high bar now. So what do you have for us today?
I'm going to turn our attention for a few minutes to the Department of Justice and healthcare and how antitrust might be in the crosshairs. Criminal antitrust enforcement in healthcare has picked up significantly in recent years and remains in sharp focus for companies and executives today. The U.S. Department of Justice Antitrust Division has made enforcement in healthcare a top priority, as the prosecution of alleged conspiracies to fix the wages of healthcare workers and agreements not to compete for their services and playing out in courtrooms all across the country. Available evidence indicates that the uptick in healthcare enforcement is here to stay. In early March, U.S. Attorney General Merrick Garland highlighted that the DOJ has the most antitrust grand jury investigations open in 30 years, and that the DOJ is seeking funding to hire an additional 120 attorneys and 900 FBI agents to support white-collar crime investigations and prosecutions. The DOJ's increase in enforcement resources is a reflection, as Garland noted, that enforcement activity will only accelerate as we come out of the pandemic. As a result, all participants in the healthcare industry, whether you're a hospital or a provider or an insurer, as well as pharmaceutical companies and medical device manufacturers, should be on alert for conduct and agreements which could lead to antitrust scrutiny. Beyond the common pitfalls of price fixing, bid rigging, and market allocation, antitrust compliance efforts include agreements not to compete for labors, i.e. no poaching, as well as awareness of the potential for monopolization of particular markets. In 2016, the DOJ began what would become a sprawling series of criminal prosecutions alleging price fixing of generic pharmaceuticals. Those charges against two executives expanded with the 2019 deferred prosecution agreement of Heritage Pharmaceuticals to resolve charges of price fixing, bid rigging, and illegal allocating of customers. The Antitrust Division has now charged 7 major manufacturers of generic pharmaceuticals, as well as at least 4 company execs with offenses involving alleged price fixing, market allocation, and bid rigging conspiracies. In April of 2020, the DOJ announced a $100 million deferred prosecution agreement with Florida Cancer Specialists and Research Institute, which we'll call FCS, an oncology group based in Florida, in which FCS also agreed to cooperate with the Antitrust Division and implement a compliance program designed to prevent and detect criminal antitrust violations. According to the DOJ, FCS improperly conspired with a compelling oncology group to allocate medical and radiology oncology treatments for patients in Florida. Executives facing individual criminal liability, however, remain at risk and would be well advised not to anticipate that they will be informally protected by deferred prosecution agreements, even under the Antitrust Division's broad leniency policy. Although in October of 2016, the DOJ warned that it might pursue criminal charges against both companies and individuals for no-poach agreements, as well as antitrust violations up until that point. In late 2020, criminal antitrust enforcement in the healthcare labor market heated up. First, in December of that year, the DOJ unveiled its first ever wage fixing prosecution with an indictment against the former owner of a therapist staffing company alleged to have conspired to pay lower rates for physical therapists. The DOJ announced its first corporate prosecution with a no-poach agreement in early 2021. President Joe Biden's executive order on promoting competition in the American economy, which rolled out a White House Competition Council in 2021, reinforced that his administration policy was to enforce antitrust laws in labor markets and healthcare, including insurance, hospital, and prescription drug markets. What healthcare industry participants can do. Effective compliance programs remain the bedrock of corporate risk mitigation, and criminal antitrust is no exception. As noted in July 2019 revisions to the Antitrust Division leniency policy, they incentivize antitrust compliance rather than simply the first person or entity to seek leniency by directing Antitrust Division prosecutors to consider the adequacy and effectiveness of the corporation's compliance program at the time of the offense, as well as at the time of the charging decision. Under this approach, the Antitrust Division resisted creating a definitive list of elements that must be included in effective compliance programs. Instead, prosecutors are directed to consider 3 fundamental questions. And we know these questions from other documents from the DOJ. Is the corporation's compliance program well designed? Is the program being applied earnestly and in good faith? And finally, does the corporation's compliance program work? Given the breadth of issues that must be considered when evaluating the effectiveness, the Antitrust Division also has issued an accompanying guide, the Evaluation of Corporate Compliance Programs and Criminal Antitrust Investigations, which includes specific antitrust risk assessment considerations, as well as training for company personnel and oversight mechanisms to ensure that personnel follow the compliance program. In addition to ensuring that the company has a robust compliance program consistent with the Antitrust Division's guidance, DOJ's willingness to use traditional criminal investigative tools in criminal antitrust investigations, including unannounced interviews, the grand jury, and search warrants, underscores the importance of training company personnel to respond to these unexpected attentions from law enforcement. Effective planning includes adopting a plan for responding to surprise contact with law enforcement, educating company personnel regarding their rights, and necessary internal notifications. Assessing the effectiveness of a compliance program can benefit the companies in high-risk areas such as joint ventures and other competitor collaborations where contact with competitors is a daily reality of business. That assessment often takes the form of antitrust audit with a dive into company documents and targeted interviews. Setting up firewalls and clean rooms to limit the sharing of competitively sensitive information and processes for counsel to monitor this sharing can also help ensure pro-competitive activities. All of these examples demonstrate how the Biden administration has increased criminal antitrust enforcement in healthcare significantly over the past few years and remains in sharp focus for companies and executives today. As a result, all participants in healthcare industry, from hospitals and providers to insurers, as well as pharmaceutical companies and medical device manufacturers, should be on alert for conduct agreements which could potentially lead to criminal antitrust scrutiny.
So, Jay, I have a question for you. Do you, and I believe in your remarks, you talked about the anti-competitiveness in the healthcare industry around individual employees, whether it be anti-poaching agreements, whether it be anti-competitive agreements in terms of you can't go to a competitor. Do you see employees as a part of the group that the DOJ is trying to protect in the antitrust world around healthcare?
Yeah, I think that's a good point, Tom. And it kind of goes like we were just talking about, what is, if the Business Roundtable said these are the stakeholders who are affected by, what a business does, I think you're right on cue here with the DOJ and them. It's almost like consumer protection that you're looking there for the employees and the people who are working in these industries, and you have to make sure they're protected from that perspective.
Ladies and gentlemen, we are now to our fan favorite of shout outs and rants. And for those who are listening to this podcast on the audio format, I'm sorry you can't see the Cheshire Cat grins of our panelists because they look like they are loaded for bear. So we're going to go in the same order. Pat Kelly, what do you have for us in way of a shout out and or rant?
Well, since I already a mini rant earlier about whether Twitter could be legalized or held as a public utility or not, I'm going to go with a mild rant for the. I'm actually going to circle back to my cybersecurity talk that I had at the beginning of the hour with the SEC proposal. As much as I like some of the governance questions that the SEC is raising, there's some other parts of the proposal there that I really kind of wonder about. And I will give you an example, is that right now, remember I said that you would have to disclose material cybersecurity events. As proposed, the SEC would expect you to disclose one of those material events, even if a law enforcement agency has asked you not to disclose it. And for everybody listening, the thunk you just heard down the hall from you was your head of corporate security fainting at this proposal. That strikes me as exceptionally risky. The SEC has some language in there that basically the imperative of the investor needing to know that a material breach has happened trounces any sort of law enforcement issues that a different agency might have. Not asking that you give away the whole store and the full details of your material event, but they do say that you might have to disclose this has happened, it's disrupted these operations, we're still trying to fix it, or we have fixed it. Like, let's think long and hard before we try to pit regulatory disclosure against effective law enforcement. I would not be surprised if this idea gets left out of the final rule. I would hope it gets left out of the final rule, but I'm still kind of wondering how on earth did it get into the proposed rule, because it doesn't seem like a good idea to me.
Jonathan Marks, we will note with interest that the Kentucky Derby is coming up, so I don't know if you'll continue that vein of rant or not, but do you have a shout out and or rant for us?
No, I'm going to go with a different ass this week, Tom. Sorry. Anyway, I have two shout outs this week. They're kind of related. One is since I'm really a Philly boy, I have a shout out to Alec Boehm, who's one of the Phillies' third basemen, who after making 2 errors mouthed something to the effect that he hates this place. And that was actually caught on camera. And if you know anything about Philadelphia fans who throw snowballs at Santa Claus, they literally eviscerated him. With the next play being that was hit to him, they gave him a standing ovation as sort of a little bit of a grin, you know what. After the game, actually, Boehm, he fessed up to the fact that he actually said it and said that he was frustrated and he loved playing here. And I can go on and on and on. But I think the one great thing about Philly fans is that if you really own up to it, you become a hero. So at his first at bat the next game, he actually got another standing ovation. So I credit this young man for actually just hanging in there and, you know, taking it on the chin and actually owning up for his behavior. And I think we've all had those days where we all mouth something that, you know, that frustrates us. But, you know, I just give him a lot of credit. I think that's great. And on the same vein, you know, history made this week with Alyssa Nakken being the first woman coach in Major League Baseball history. So I thought that was an interesting moment as well. Good for her. You know, if you follow her story, she started as an intern and worked her way all the way up to the top. And I just think that's something that these young kids today really need to understand. You really do have to start at the bottom and work your way up. Despite, you know, what some of the younger folks have told me, you can't just apply for a job and automatically on day 2 expect to be the CEO.
Karen Woody, do you have a shout out and or rant for us today?
I actually have a rant this week, and it's a rant I've been making for a lot of years, but we see it again just about a month ago, and this is kind of a nerdy one. It could be, maybe it should have been what I actually talked about on the actual show, but a month ago, March 18th, the DOJ issued a declination with disgorgement. And I just don't get it. I mean, the number of times I want to say that word doesn't mean what you think it means. The declination with disgorgement that happens on March 18th was with the agreement was with Jardine Lloyd Thompson Group Holdings. And the gist of it is this company gets in trouble for FCPA problems, and pursuant to the now corporate enforcement policy, which is the codification of the pilot program that sort of launched this declination with disgorgement idea. Pursuant to that, they, again, issue a declination with the strings attached that the JLT group, this company, had agreed to disgorge about $29 million to actually the SFO, so the UK Serious Fraud Office. So we have a number of players here. There's a signed letter for it. And my rant is that there is a signed letter. And even in page 2, the top of page 2 says, pursuant to this letter agreement. And so my rant is that this is a non-prosecution agreement. That is not the same as a declination. So my rant is, again, I think words matter. I wrote about this almost 10 years ago when they started this. I've taken a lot of critique for it, and you can still come at me, but if you decline to prosecute, you cannot do that with strings attached. You can say, like, we won't prosecute you as long as you give us this money. That is a shakedown. That is not a declination. So call it an NPA because it is. That was my rant.
Jay Rosen.
All right, this is going to be difficult because my word is going crazy here and it has destroyed my story. So I will talk about this in general terms. I read something very touching in the Washington Post today, and you know me, I don't usually do touching, but there was a guy who worked in a produce aisle at the Publix in Florida. And every weekend, a mom and her little girl, Fiona, would come in and she would come up and see this man, Gilnet, and give him a high five. And she called him high five. And she'd see him every weekend. And this was kind of like a ritual going to the Publix. Well, what happened was she kind of stayed away for a couple of years due to the pandemic. And then her parents decided to bring her in to see high five again. It goes on in the story that he bought her a pink bicycle for her birthday, and just a very touching thing. And it made me think about when I was a little boy in Manchester, New Hampshire. My mom used to take me to the Johnny Bank. And the reason we called it the Johnny Bank is because there was a coloring book that talked about how Johnny could save money by going to the First Federal Bank. And every Saturday I'd go to see my friend, who I called her Pal. I don't know if her name was Pal, but I'd go to see Pal and I'd get my lollipop. So I'd like to send a warm and fuzzy shout out to Gilnet, to Fiona, and all the Pats who reach out to their local communities, who tie people together, who build roots, and who do the nice thing. And in the show notes, we will have a link to the video of showing the reunion between Gilnet and Fiona. And that's my positive non-rant for the day.
So I'm going to start with a shout out, but you will see how quickly it evolves. And my shout out is to Margaret Atwood for writing The Prophecy of the Handmaid's Tale. You might think this is dystopian science fiction, but The Handmaid's Tale is actually alive in the great state of Texas in 2022. Now, I am not referring to the lieutenant governor who is now going to boycott Disney World and Disneyland because they actually spoke up about the anti-gay law in Florida. I'm not going to talk about the attorney general who has said the laws of the state of Texas don't apply to me. I'm not going to talk about the governor of the state of Texas who decreed that parents of transgender children would be investigated by the Department of Social Services or Child Protective Agency for child abuse and perhaps criminally prosecuted, or his bottling up of our foodstuffs at the border so that he can make a political point. I'm going to talk about the prosecutors in Starr County, Texas, who brought a criminal murder charge against a woman for having a miscarriage. Yes, you heard that right. They brought a criminal prosecution, charged a woman with murder for having a miscarriage. She was booked, she was put in jail, and she had to post bond. Here's the thing. There's no law in the state of Texas which criminally or makes it criminal for a woman to have a miscarriage, even if that miscarriage is based upon a self-abortion. But taking it to Margaret Atwood's level, that's now apparently the law in Starr County. Now, the prosecutors dismissed this charge when it was pointed out numerous times by numerous commentators that the anti-abortion law in Texas applies to those third parties who provide abortion services. But frankly, I can't think of a more larger example of the dystopian society that we now live in the great state of Texas than to charge a woman who's had a miscarriage with murder of her unborn child. So Margaret Atwood, you didn't write science fiction. You just wrote a prophecy for the state of Texas in 2022. That's my shout out. Well, on that cheery note, ladies and gentlemen, this has been a great episode of Everything Compliance, and we'll have to see what gifts keep on giving for the next time.
All right.